We're getting the understanding about what is law and specifically what is the difference between law, ethics, and then the positions of law as a norm within other social norm. Next, we're going to discuss the sources of law, or in bahasa sumber-sumber hukum. Sources of law, what are the definition, and then what are the types of sources of law. We're going to discuss that in this PowerPoint presentation. As I mentioned before, we're going to discuss the definitions of sources of law. Next is how we classify sources of law and what are the types of formal sources of law. What is formal sources of law? It's a types of sources of law accordingly to the way the sources of law is made. There are two definitions of sources of law. The first is where the law is found, meaning because this is something relates to binding norms, everyone bind by it. Everyone has to oblige to the law. So when someone asks you, what about Indonesia regulation on labor? So you may say that, oh, we got this law on labor. And also recently, 2020, we also got the law on job creation, or in bahasa Undang-Undang Cipta Kerja. So the first definition talks about where the law is found when someone asks you about an issue. In Indonesia, for example, because it is binding norms, typically the authoritative officer can force the implementation. It's different with the second definitions of sources of law. It's answer the question where the law is stuck. For instance, when in deciding a case, judges may look at not necessarily binding norms, but try to find living laws or um, customs in society, values, for instance, justice and other types of values within the society in order to make a good decision. When it comes to lawmaking process in the legislative institutions, such as in Indonesia, House of Representative and the President, they the law from the sources of law, not only from the binding norms, but also not a binding norm such as values that I mentioned before. Typically, the strength of this non-binding law is persuasive. So many, for instance, judges look at the previous judge's decision. In Indonesia, it's different with Commonwealth system. Look at to judge's previous decision is not compulsory in continental system like Indonesia, but it is persuasive for judges to look at previous judges' decision in order to create certainty, legal certainty within the law enforcement in Indonesia. So that is the difference between the definitions of sources of law, where the law is found or where the law is done. Practically speaking, there is this theoretical classifications of sources of law. In historical sense, when we look at sources of law, we're gonna understand what's going on in the social and political and economic context in a country. Legal sources or sources of information, everything that can provide information about law. As I mentioned, when we look at the history of lawmaking in such issue, we're gonna understand it as a sources of information about the law itself. And second, sources of law in historical sense means that the sources of material, such as sources for lawmakers in making laws. For instance, if we look at the history, when Indonesia lawmaker created this law on alternative dispute resolution and arbitration, they look at to Indonesia's civil code, which is originated from the colonial government. So that's sources of law in historical sense. While in sociological sense, sources of law is defined and associated with the society itself. Sources of law, as I mentioned previously, where the law is dug, where the law is explored, become the materials of the law itself is the what's going on in the society. It can be custom, habits, religion, morals, values, economic needs, and etc. For instance, under the Suharto leadership in Indonesia, it was categorized by many as authoritarian government. And then we could see that the law made at that time reflect what the government wanted, limiting public participation, for instance, and close the opportunity for popular election at that time. That's what's going on under the authoritarianship era. So my question is, what do you think about Indonesia right now? Or you can also mention other countries in the world. Does the situation in the country, political situation or economic situation reflect the lawmaking in certain country? So that's for your food of thought. In historical context, as I've mentioned before, Indonesia legal system, for one, is rooted from the colonial Roman Dutch law, and we still use it. However, not only that Roman Dutch law that exists, but also Indonesia customary law, Islamic law, that created this type of sources of law in Indonesia, which is pluralistic. So if you look at, for instance, in the family law in Indonesia, you're gonna see that the sources is not only the state law in Republic of Indonesia, national law, but also Islamic law, but also customary law in certain parts of Indonesia, and also we still use the civil code introduced by the Dutch colonial government. Next is the classifications of sources of law or types of sources of law, material sources of law, and also there is this formal sources of law according to Algra. Material sources of law talks about where the law is dug. It's the same with the definition or the second definitions of sources of law. So when it comes to material, we talk about where the substance of law is uh, explored or is collected. So I already mentioned before, economic structure, legal system, religions. So it can also comparatively came from the other countries, as many countries learn from best practice in other countries. Specifically in Indonesia, it is put it into the law on lawmaking, law regarding lawmaking, pembentukan peraturan perundang-undangan, that uh, some of the values, philosophical value must be put it into our nation of law, such as justice, such as welfare, Pancasila, in order to create the prosperity of Indonesian people. Second is formal sources of law. Legal sources is for informal sense are called sources that cause the effect or the causal efficiency, sources that impose law. Formal legal sources that have been formulated into a form certain formalities that cause the regulation to be positive law. So what is positive law? Positive law is binding law that is enforceable within a specific area, a country, for example, at that time. Okay? So when people ask what is Indonesia positive law on infestation, you can say for an infestation, you could say that, oh, we got undang-undang tentang penanaman modal asing, law on foreign investigation. So that's the example. So when people say positive law or hukum positif, it's the formalities of law itself that make the norm can be binding. There is certain formality that should be fulfilled. If material sources of law, we talk about the content, the substance. Formal sources of law, we talk about the formalities, the way the law itself made. Informal legal sources, the legal view or legal awareness of community is formulated by the government in certain form. We're going to discuss further what types of formal sources of law next. Formal sources of law, according to jurists or legal scholars, Van Affelder mentioned act, law or statute, custom, conventions. Those are the binding laws. And he also mentioned that contract, judgment law, and doctrine, it is also binding to creating regulation that help the lawmakers to create regulation. The second one, the contract, judgment law, and doctrine, this is we can refer it as the material sources of law for the first line, statute, custom, and convention. Meanwhile, according to Peyton, formal sources of law includes custom, judicial method, statutes and code, legal thought, and doctrine. According to Belfoy, quite the same, but he mentioned justice system. Next is CST Council and Utrecht. The same with others. Sudikno Mertokusumo, he mentioned that the sources of law that mentioned before, it's not limitative. He also include doctrine, contract, legal consciousness as parts of formal sources of law. So again, formal sources of law meaning that we classify law accordingly to the formalities, to the way the law is made. Material sources of law, we talk about the substance or the contents of law came from. That is all for first part of sources of law.